NACDL is the association of the nation's criminal defense bar.
Thank you for joining us and welcome to Preserving the Sixth Amendment, Practical Considerations, Constitutional Challenges, and Lessons Learned. I'm Monica Milton, Public Defense Counsel for the National Association of Criminal Defense Lawyers. This webinar is being conducted as a part of the Justice for All Strengthening the Sixth Amendment grant. Partnering with NACDL on this webinar and this grant is the Association of Prosecuting Attorneys, the National Center for State Courts, and Research Triangle Institute International. This webinar is supported by grant number 2019 YABXK0001, awarded by the Bureau of Justice Assistance. BJA is a component of the Office of Justice Programs. Points of view or opinions in this webinar are those of the speakers and do not necessarily represent the official position or policies of the U.S. Department of Justice. With that said, I want to welcome you to our program. So I just want to introduce you to our speakers today. We have our moderator, Professor Andrea Roth from UC Berkeley. You may remember her from last time. We have Judge Annie O'Connell from Kentucky, criminal defense attorney and NACDL's President-elect Martine Sabelli from California, and DeKalb County District Attorney Sherry Boston. With that said, I'll turn it over to you.
Hi, well, thank you so much. It's such an honor to be a part of this distinguished panel, and I'm excited to hear about everything that's going on in your respective jurisdictions. So I thought perhaps we could start out just with a general overview of what's going on in your jurisdictions in terms of virtual proceedings, in terms of modified in-person proceedings, just general sense of where things stand on November 19th. So perhaps we could start with Judge O'Connell. And then hear from Ms. Boston, and then hear from Mr. Sabelli. So Judge, what's going on in Kentucky?
Thank you, Professor Roth. Thank you, everyone, for inviting me to participate in this panel. I'm really looking forward to this discussion. Before I tell you where we stand, let me just give you a little sense of the kind of court that I'm in and the population that we are serving here in Jefferson County, Kentucky. Louisville is the seat of Jefferson County, Kentucky. That is pronounced Louisville, not Louisville. Our population here in Jefferson County, I looked earlier today, is about 766,000. It's the largest metropolitan area in Kentucky. That population puts us on par probably with other jurisdictions like Memphis, Tennessee, Indianapolis, Portland, Oregon. So that gives folks listening a sense of the kind of, or at least the size of city where my court resides. In Kentucky, we have 120 counties, and they're a mix of rural and urban counties. And so my experience in Jefferson County is probably very different than the experience in, say, Metcalfe County in Kentucky. I am one of 13 circuit court judges. Our courthouse, I once heard, is the busiest building in the entire state. It's open theoretically open 365 days, 24/7. Although I've often wondered if the qualification should be that the buildings that we're talking about are government buildings, not, for example, university or sports stadiums, because I think that probably the sports stadiums here in Kentucky might rival us. But as of last month here in here in Kentucky, we had over 33,000 criminal cases pending. And here in Jefferson County, we have over 2,000, is about 2,600 criminal cases active and pending right now. Where we are now, as far as the pandemic goes and the way our courts are operating, at least circuit court, and I'm just talking about circuit court, not district court here today. As of about a week ago, our term of circuit court judges, there are 13 of us, came to consensus that we needed to suspend trials completely until the end of 2020, until the end of the year. This was a difficult decision for us, but this, of course, was based on the recent data regarding the surge and pandemic positives and guidance from our Kentucky Supreme Court about court proceedings. So as we stand right now, everything is remote. Our normal docket hearings are remote, although each individual judge still retains some discretion about whether or not to host in-person hearings. I have done so occasionally, for example, competency hearings or evidentiary hearings, other types of evidentiary hearings. And that gives you a snapshot of where we are. Certainly I can get down more into the weeds about how that's working, but just to give you a sense of where we stand today here in Louisville.
All right, thanks a lot. Ms. Boston, what's going on in Georgia from your perspective?
Hi, so thank you so much for having me here. It is an honor to be on this esteemed panel and to give you an opportunity to hear what's happening in Georgia. I am the district attorney in DeKalb County, Georgia, which is technically the Stone Mountain Judicial Circuit. Our circuit comprises a part of the city of Atlanta and then some of the surrounding suburbs. We have been under an judicial emergency order in our courts since March the 13th. The Chief Justice of our Georgia Supreme Court has signed up until today 8 consecutive judicial emergency orders. So in Georgia, just kind of speaking broadly, for most of this year, all of Georgia has been under a uniform guideline. Each time the Chief Justice of the Supreme Court has signed an order, the local chief judge in the individual circuits, and we have 49 judicial circuits within Georgia. Each of those judges then signs a local order that continues to designate all of the courts within their system. So we have grand jury was suspended until a few weeks ago, and jury trials have been suspended up until a few weeks ago, although based on my knowledge of what's happening in other circuits in the metro area and around Georgia, there are only a handful of jurisdictions that have actually conducted an in-person jury trial. When it comes to DeKalb County, where I am, which again is part of the city of Atlanta and the suburbs of Atlanta, our courthouse, under our guidance of our chief judge, has remained, we still have not started any in-court person proceedings, with the exception of grand jury, which we just started last week. And that will remain in effect until at least December the 10th. Although I suspect another order may be coming because of the increased numbers in our jurisdiction, that many of our judges may be hesitant to resume in-court appearances for our cases. We are currently set to begin jury trials next year in January. Again, I think that may not happen, but that is the plan. And so all of our court proceedings right now in DeKalb County are being done via Zoom or WebEx, depending on whether it is which departments we're dealing with and what functionality they're using. So we still remain in a virtual posture, and I suspect we'll be ongoing in this posture for some time.
All right, thanks. Mr. Sabelli, the Bay Area. I know a bit myself, but I'm not in the trenches. So what's going on in San Francisco and around?
Well, the trenches are pretty full right now, in the sense that the trenches have gotten smaller. Most courts are not operating at full speed. And thank you, by the way, for the invitation. It's an honor to be here. Federal courts in San Francisco are open. They're open in a sort of strange, ethereal way, in the sense that there are some proceedings. Most all of the proceedings are virtual. There are still some jury trials because there is no central control really over what a federal district court judge can and cannot do directly. They're making their individual choices. Some judges have held trials. Sometimes they've held trials with certain kinds of promises semi-extracted from lawyers, as in if you end up without, losing a couple of jurors, will you be okay with 10 jurors rather than 12, that sort of thing. But in federal court, there has been this progression towards normalization without getting anywhere close to normal, but judges sort of pushing to do more and more. Lots of the pretrial hearings are virtual. Some judges have made some arrangements to bring a couple of defendants in on the larger cases so they can be present, physically present, but obviously we can't do the work that we used to do. So there's a kind of a hybrid situation here in federal court that requires a lot of work and a lot of research in terms of being sure that you can adequately represent your client, specifically adequately consult with your client during hearings, which has been very, very difficult. But there are some jury trials going.
So I'd love to loop back around to you to ask some more specifics about the attorney-client relationship in particular. But maybe I can piggyback off of what you've all just said about what's going on in your jurisdictions and ask about challenges that have been brought. Maybe we can put aside the jury for a minute, but and fair cross-section issues for another minute. But Judge O'Connell, you mentioned that trials would be suspended till the end of 2020. Have there been motions either to try to dismiss cases as a remedy for, say, a speedy trial violation, either that or motions to try to get a virtual trial going, whether, a bench virtual trial, whatever it is, but have there been some motions, presumably mostly from defendants, saying, we want to go forward in some way? And what have you seen in that respect?
So the short answer to that is, at least in my courtroom, no. And I haven't heard of any of those motions being made in our circuit, though it's possible that that's happened. Since the court, I call it shut down, though court has never actually really closed since March. We have had, in Jefferson County, we've had one civil trial that was in my courtroom, and we've had 2 criminal trials. Both of those criminal trials, to my knowledge, resulted in convictions. And I got and I probably shouldn't speak about why they ended up going, if that was from the defendant's perspective, if the defendant was pushing for it, if that was the judge's preference, or how those ended up making it to trial over everybody else. I can tell you in my courtroom, my experience has been that most criminal defendants don't want to be the first one to go. They don't want to be the guinea pig. They don't want to be the experiment under these circumstances. And frankly, I don't blame them. As a former defense attorney myself, it's hard for me to imagine what, for example, a robbery trial would look like, with where the defendant is accused of having a mask on, and then having the defendant needing to sit at counsel table with a mask. Not to mention all of the issues about jury selection with potential jurors with masks on, and all kinds of other logistical problems beyond not to mention the fair cross-section questions, all of that stuff. So that's my longer sort of answer to no, I have not had to entertain any of those motions so far.
And just a quick follow-up, have there been motions, I don't know, for lesser remedies, for example, we don't want to be the guinea pigs, we don't want to go to trial now before anybody else wants to go to trial, but we want to be out of pretrial detention if we're going to be waiting until next summer for a trial. Is there anything?
Yes.
Yeah.
Yes. At the beginning of all of this, earlier this year, there were a number of measures taken both locally and statewide for modifying release and conditions of release, trying to get folks out of jail safely and try to curb the spread of the virus within our state institutions and local jails. And I have entertained motions, of course, based on reasons related to COVID susceptibility, underlying health conditions, those sorts of things.
Got it. And then in DeKalb County, Ms. Boston, have there been challenges from the defense that you've seen, either to push forward with some virtual modified proceeding, or to somehow get a remedy for a speedy trial violation or along those lines?
So in Georgia, we have not had any virtual criminal jury trials. And one thing that I have been, through this public health emergency, felt really grateful for in Georgia is that we've had a uniform system, because we did have a statute and a preparation plan that allowed our Chief Justice to take the reins, create these orders, and basically set the playing field across the state of Georgia, so that you didn't see some jurisdictions saying, well, we don't have any cases, so we want to continue to have jury trials, and then other jurisdictions try to clamor to figure out what to do. So as a result, it's been uniform. Under our public health statute, our Chief Justice has been able to also suspend statutory norms. So our speedy trial terms have been suspended. The number of days that you have to indict a case has been suspended. So almost all of those deadlines, all the deadlines that we have within the system on both sides, as far as filing documents, all of those things have been stayed and still remain stayed. So we have not seen any lawyers filing anything, in part because those orders are very clear, at least right now across the board, that those deadlines cannot be imposed as long as Georgia remains in a judicial emergency. Now, we have absolutely seen bond motions asking for remedies based on conditions specifically in jail, or people with underlying health conditions that may be a risk to COVID-19. In our circuit, I work very closely with our public defender, and I never miss a moment to say on any national call that I am lucky to work with the best public defender's office, I think, in the country, led by Claudia Sari. And so she and I, along with the chief judge, besides being on the COVID task force, she and I started meeting weekly when the pandemic began. So I meet with our public defender, our conflict public defender, and our chief judge every week. So we have discussed the prevailing issues that continue to be of concern. And so we have worked together to come up with solutions where we can to make sure that the criminal justice system is moving along in the way that we can protect all of the parties in the system. So that has been really helpful for us, as approximately our public defenders represent about 88% of the cases within our criminal jurisdiction in my circuit. So they are the largest voice, and most obviously they represent all the people, most of the people that are incarcerated, which is the class of person that's obviously being most harmed by the pandemic.
And as you can expect, there's the chat is lighting up with public defender offices saying that they're the best. They're the best. So we hear you. We hear you. A couple of follow-ups to that. I could imagine somebody thinking, well, it's interesting, even if the statutory deadlines have been told and all the orders are very clear, you might expect some Sixth Amendment arguments as to why the speedy trial violation needs some sort of remedy. But do you feel like perhaps like Judge O'Connell said, that maybe it's that so far defense attorneys have not seen it as in their interest to push that issue? Or
I wouldn't say interest as much as I would say, we have worked very closely with our public defender to make sure that we are addressing the issues. And in my jurisdiction, interestingly enough, the chatter that we're starting to hear from the defense bar is really not about the speedy trial. They're more concerned about the deadlines that normally are imposed for us to indict cases. In my jurisdiction, if a case has not been indicted within 90 days and someone remains in custody, that person would normally be entitled to a bond if they have not received a bond, or if a judge has denied bond. Well, that is obviously, we have lots of people that have been sitting in jail since March 13th whose cases have not been indicted, and it has been longer than 90 days. So what we're seeing right now first in my jurisdiction is a push for pressure for the Supreme Court justice to lift those types of rules. Because now they're saying, hey, grand juries are reopened. We really should impose those deadlines back and force prosecutors to start to indict these cases within the 90-day rule. So that's the main thing that I see is happening first. Most of the defense lawyers in our circuit are not willing to entertain virtual jury trials. Neither are the judges really, and we can see all of the drawbacks that can happen in a virtual jury trial. And in my jurisdiction, our public defenders don't even want to do any substantive motions via Zoom because of the right to confront your witnesses. And there is an argument that you can't fully confront a witness via Zoom or some other, media, non-in-person media. And we have supported our public defenders on that. If anyone chooses to waive that because they say, listen, we're going to waive it, we want to do this hearing, it's important, then we'll consent. But we've stood by the proposition that unless we have the consent of the defendant and defense counsel, we continue to maintain that we can't do these types of substantive hearings via Zoom.
All right, and there's some follow-up questions already in the Q&A, but maybe we can hear from Mr. Sibeli first, and I'll loop back around. So, obviously there's a constitutional right to an indictment in federal court that we don't see in every state, or in California, there's no even statutory right to indictment. But have you seen or made defense challenges with respect to any of these deadlines, either indictment or speedy trial? What's going on?
Sure, there is some creative work out there being done on motions with respect to the effect of the pandemic. Taking the sort of 50,000-foot view for a second, based on the US Constitution, it would be tough to agree to a virtual jury trial given the right to confrontation in the Sixth Amendment. Some states have that same right attached to pretrial proceedings. California, most states don't. And if you've got a right to confrontation in a pretrial proceeding, you got to think long and hard about waiving that. Certainly, I don't think it'd be tough to waive it at the trial stage, given the Sixth Amendment mandate. There is some leeway there in certain very limited situations defined in part by Maryland v. Craig and some very extraordinary situations. It'd be kind of tough to waive the right to confrontation at trial, particularly given the fact that there is social scientific literature that tends to demonstrate that virtual proceedings de-solemnicize, make it less solemn and less serious venture for individuals like jurors when they're assessing testimony. But the real sort of frame here is the fact that if we're having these discussions about what's safe in the courtroom, then there's a whole preceding set of assumptions about what we can be doing as defense attorneys before trial. And if we're having these debates about what's safe in the courtroom, then you know that spending time with our clients in jail, or spending time with our clients in our offices, or sending our investigators out to talk to people, or having team meetings, or meeting with experts, or sending our experts to meet with our clients, it ain't happening. And so the whole idea that we can push inexorably towards trial in this context is really is based upon a set of assumptions about what we can get done to be ready for trial. And if we're arguing about what can be done in the courtroom, and we probably we're not setting up this, we're not doing the Sixth Amendment work we need to do in terms of investigation, experts, and our own, building our own attorney-client relationships. I got a client who was indicted in a large federal RICO case right a couple days before San Francisco shut down. I've only seen him in person once. I see him all the time on video calls, but I have not been able to construct an adequate relationship of trust with him because very difficult. Neither of us really trust Zoom. I can't give him documents. We can't sit and talk. It's very, very, very difficult to do that. So in this context, some people have pushed certain things. So for example, there was a trial in San Francisco that had begun before the pandemic, was frozen, and then reinitiated because no matter what the result, this client would have been given less time and would have been deported to the country that he came from, which was Russia. And so that lawyer, the client really wanted to go forward because he was in a jail during a pandemic, and no matter what, the result would have been release. So in that circumstance, the lawyer, despite the mandates of the Sixth Amendment, despite his or her own private personal health concerns, feels a real pressure from the client to go forward, and in that case did. The judge in that case put a lot of pressure on the lawyer before resuming. If we lose a juror, will you agree to only have 10 jurors or 11 jurors? If we lose a second juror, will you agree to 10 jurors? So there's a lot going on here that is not sort of normal. A lot of pressuring, and I think it takes some backbone on the part of lawyers. It takes backbone to say, I don't want to do this because I live with my 83-year-old mother, or because my spouse has a comorbidity, or because I'm 68, or whatever. And so there's a lot of work, and the NACDL will have your back on this. If you're an NACDL member and you're being forced to go to trial despite these concerns, let us know, please. The strike force will have your back on this thing. But to sort of come in for a landing on this, there are things we can do in the interim, but it takes a lot of thought and a lot of ingenuity. The due process requirements to pretrial hearings don't necessarily mandate physical presence of the client or physical presence of the witnesses if it's an evidentiary hearing. But sometimes due process requires you to be in the same courtroom with the witnesses. Sometimes due process requires you to be in the same place with your client so you can consult with him or her in the moment. Sometimes not. And it takes, there is no sort of cookie cutter here. We've all got to work through it. But I will say to my brothers and sisters on the defense side, the fact that judges, and no particular judges are being singled out here, Your Honor, the fact that some judges want to clear their dockets ain't a reason to press forward. And we're seeing that across the country, that there is a need that judges perceive to keep, to show that they're working and clear their dockets and push matters. And that is not a reason to move forward. You need to figure out whether or not you can really get a constitutionally adequate trial for your client. And I think the studies show that virtual proceedings, particularly virtual jury selection, is really problematic.
In terms of sentencing, where you don't have a right of confrontation or the jury isn't an issue, I know there's lots of in-person sentencings in federal court in the Bay Area. Has that been the norm as compared to virtual sentencings, or have there been strategic calls one way or the other on that?
So, federal judges decide how they handle their own calendars. There's no, in their own practices, there is no uniform rule that has been imposed on them. With respect to sentencing, there have been some mechanisms that have been created, developed, or used more frequently to take care of lighter cases, uncontested cases, fast track cases, where virtual sentencings occur because all the parties agree this is a case where there's really no dispute. Let's get this person sentenced, let's get them out, let's get them deported, whatever it is. And there's a fast track process. It's very easy, no hiccups, no physical presence, nobody's health is at risk. And then there are other cases that are heavier cases where judges have largely insisted that there be in-person sentencing. I'm not sure whether that's born of some sort of instinct to, I'm not a judge, and there's no surprise that I'm not a judge given the way that I look at the world, but there may be an instinct on the part of certain judges to make sure that they're looking at a defendant eye to eye and saying, and saying, you murdered this person, and I want you to hear from the victims about how you've affected them, right? So there have been a whole set of really heavy sentencings that have occurred in that context. And boy, are they tough, because you're masked. Everybody is already in this weird sort of tense space. It's a very, very bizarre process. I really, it's very difficult to go through. I've been through a couple of them. I think that there are studies being done mostly in the civil side about the effect of the pandemic on the perception of the value of life. No surprise that this has been done in the context of torts litigation and all that kind of thing. It hasn't all played out yet, but it is a different thing in a context in which almost 250,000 people have died around us, maybe more, maybe a little bit less from the pandemic, to talk about the value of human life. And it has really changed the nature of these proceedings, but they are occurring.
We have a couple of suggestions, or not suggestions, requests from the chat for sites to some of those very helpful studies that you mentioned. And I don't know if that's something that the hosts can facilitate, but there's been folks who are asking. And I also wanted to mention, oh, go ahead.
This is the lead study on sort of the effect. There's a lot being done on neurologically on Zoom and the neurological capacity of the human mind to concentrate on a screen for how long. This occurs quite a bit in the context of higher education pedagogy, because you see that these schools are limiting Zooms to like 45, 50 minutes because they know people can't focus. There's also some work being done on virtual proceedings. Sherry Diamond from Northwestern had a really interesting study on the effect of virtual proceedings on pretrial hearing. That's in the Northwestern Law Journal on pretrial proceedings in Cook County. Shows that people are much more likely to be detained if the hearing is virtual as opposed to non-virtual. There was a lot of work done on this actually in Europe, having to do with virtual proceedings related to alleged terrorist acts. So there's a bunch of stuff out there. Maybe I can try to get some of that to Bonnie and to Monica.
Yeah, I think Ingrid Eagley at UCLA also has one in the immigration video proceeding context. And just to mention another point in the chat that someone made, in another federal district, judges have been giving extra acceptance of responsibility points for Zoom sentencing, seeing it as protecting the community, which is interesting. Going back to Judge O'Connell and Ms. Boston, there are some questions in the Q&A about how, with respect to grand juries, how grand jury secrecy has been ensured or not. I don't know if the grand juries are reconvening. Ms. Boston, I know it's only been a week, but reconvening virtually or in person. So maybe, Judge, we can start with you, but thoughts about grand jury secrecy or handling those jurors in general.
So our grand jury started meeting again, I think in July was our first grand jury that was convened. Prior to that, the Kentucky Supreme Court did extend deadlines for indictments. Ours is 60 days here in Kentucky, and so those were some of those pending indictments were granted extensions. We started with our grand jury for the first couple of terms meeting not in our courthouse as they traditionally have done, but at an off-site building, government building that is much larger, that enabled everyone to socially distance appropriately. All of our grand jury proceedings, of course, are secret, and so there was no need to have any of that any of those internal workings and proceedings and deliberations and presentations recorded. The only thing that needs to be recorded is the return of the indictment. So for the first couple of terms, the grand jury met off-site, and then when they were ready to deliver the indictment back to the sitting grand jury judge, they did so either by Skype or by Zoom, which was recorded by the judge, and that then created that record. So the confidentiality, I think they had a deputy with them, of course, a presenting prosecutor, but that's how those proceedings went. Then, I guess, starting in September, they returned. I think they essentially had overstayed their welcome at that particular building, and we had to start looking prospectively into making other arrangements. They returned to our courthouse and ended up taking over our Court of Appeals courtroom, which is much larger than any of our normal trial courtrooms. The Court of Appeals has graciously offered that space, and they have been meeting and deliberating in there since then. And that's nice too, because that then those courtrooms are outfitted with our normal recording technology. So I think that's gone about as well as it could from a confidentiality and just sort of procedural standpoint here in Kentucky, or at least Jefferson County.
And Ms. Boston, what about DeKalb County?
So although we've only been back for a week, it seems like a year given all the excitement that we've had thus far with our grand jury. So similar to what the judge said, the space in our normal grand jury space located within the courthouse in no way, shape, or form would allow 26 people to social distance in the room. So we had to secure an alternate location, which we did, that allowed us to draw out a plan where each person would have their own 6-foot table and chair associated for themselves, so they could be distant, clearly distant, and everyone have their own space. So that was the first thing we were able to do, and that's worked out very well. The other thing we did in anticipation was, prior to the pandemic, our grand jury worked off pen and paper. So all the indictments were held by the foreperson, and they would be signing things, striking through everything in person. Well, during this pandemic, one of the things we've done in our court system was to migrate to as much of a paperless system as possible, limiting the need for people to pass documents or be close enough even to pass documents to one another. So we completely changed our grand jury. We included them in our technology upgrade, so that in the room they're deliberating, there are 3 or 4 very large smart boards. The indictments are placed on those smart boards, and they had been given access. But we created a system where our grand jury would enter into the queue. So the foreperson and the assistant foreperson have a keyboard that, again, it belongs to them and no one else touches. And they operate the system and sign their signatures and do everything so that we're not touching paper or having to move that paper. And then they are, when the grand jury is completed their deliberations, we created a system where those documents are sent securely and electronically through a queue directly to the sheriff's deputy, who is responsible for maintaining that secrecy until an attorney goes into open court and it's presented to the judge later that day. So we have used technology to also decrease the need for people to even have to even be within 6 feet of one another. Having said that, last week we picked our grand jury. We did do our grand jury selection process virtually. We gave a virtual option because we thought it may encourage people to show up for duty. Interestingly enough, 50% of the people showed up in person, even when given the option to show up virtually at home. So that was an interesting tidbit that we learned. And more importantly, the feedback we got was people were just ready to get out, even if it was for jury duty. So we did do that selection process. And then once the grand jury was selected, they were required to come in and operate in person, and they were sworn in. And on day one, at the lunch break, we had our very first COVID exposure. And so we had planned for this, but we didn't think it would be day one. We had selected 2 panels of 26. So we had our backup grand jury that was seated on the bench. They were sworn in and oriented and then told that they were back up and sent home and would likely not get a call. And here we are at the end of day 1, the beginning of day 2, having to relieve and quarantine our grand jury A and call up and swear in our grand jury B. So that was a lesson learned. But had we not convened that second backup, we would have been behind. We would have lost potentially 14 days. So everyone has to be contemplating, even when you're doing these things, whether it's we're back selecting jurors for petit juries or doing grand jury, you have to plan that there is potential for there to be an exposure where you may have to lose an entire group of people. And these are the types of things that we never had to worry about before, but you have to have these contingency plans in place now.
So building on that last answer, I guess another question a couple of questions that we've gotten from the Q&A relate to jury selection, fair cross-section, and just in general, which way these trends go in terms of advantaging one party or the other, which I think relates in part to who's showing up for jury service or who's being selected. So if I know that in general, jury trials have been suspended, for example, in Georgia, but it sounds like all of you, in all of your jurisdictions, there's at least some jury selection going on, either at the grand jury stage or at the jury stage or both, so, petty jury stage or both. So maybe starting with the judge and hearing from all 3 of you, thoughts about either what trends you see right now in jury selection, what challenges you anticipate in the future, even as we go back, given different risk groups that people fall in.
So I think one of the things that this pandemic has done for all of our institutions, and this is not a fresh take by any stretch coming from Judge O'Connell, but it's helped highlight weaknesses and flaws in all of our institutions. And one of the flaws I think that it has helped highlight it in the judicial system is our lack of data about, especially demographic data, about potential jurors and well, let me just say about potential jurors and stop there for a second and I'll explain what I mean. So my courtroom was scheduled to hear a part 2 of a 2 co-defendant capital murder trial where the Commonwealth is seeking death for the month of September. And about a week, 10 days before we were scheduled to begin, the defendant filed a motion to continue. And I pulled up that motion here just because I wanted to use it as a point of reference. Those folks listening may appreciate that the first subheading or title of in the memorandum is Introduction and Factual Background, Pandemic, Economic Depression, Civil Unrest, and Racially Charged Presidential Election. And I thought that pretty well summed up where we were about 10 days before that trial was scheduled to start, because Louisville, of course, has seen, just like the rest of the country certainly, but has acutely felt the civil unrest that the country has seen here over the past year. The presidential election, the defense attorney argued, was relevant because our jurors very well could have started deliberating in that trial the day before or the day of the presidential election. The defendant in that case is Black, and the victim in that case is a white woman, a Black man and a white woman, and it's a murder and rape charge. So, and I know I'm sort of taking a long way to get around here, but one of the things that defense counsel did a really nice job of was at least trying to articulate what we know about the populations that are more affected or more often affected by COVID-19 and how that may affect the jury pool that we would be able to draw to the courthouse to sit in that particular trial. This was also in conjunction with the Kentucky Supreme Court's orders that granted automatic exemptions for jury service for various populations of folks who have experienced hardship, whether that be related to health or economic hardship due to COVID-19. So I was entertaining this motion to continue based on essentially speculation that the jury pool that we would be drawing from would be different than and potentially not reflective and not a fair cross-section of our population here in Louisville. And that's what I meant by our lack of data. You know, we don't ask folks to identify themselves when they return their juror qualification forms to identify race and ethnicity, and for good reason. I mean, there may be reasons to do it, may be reasons not to do it, but we don't. So of the juror qualification forms that I received and then granted exemptions and excuses for based on COVID-related requests, I couldn't say for certain what that population looked like or what it would look like. So I was left to consider that motion without real hard data. And really it was, I said the word speculation, but it's more than speculation in that we do have data about how COVID is affecting populations differently. We just didn't know how that was going to play out. I ultimately, and not to get into the weeds of that case, I ultimately granted a continuance reluctantly because that defendant has been sitting in jail waiting for trial literally for 6 years on this case. But it was the defendant himself who appealed to me personally about this issue, as well as with the support of his defense counsel, and the Commonwealth's attorney did not object to the continuance. So I ended up granting it and didn't have to make findings about what potential effect the presidential election might have on the case, for example. So that being said, I have now seen juries, both one grand jury, I was the sitting grand jury judge for the month of September, and then had a civil trial in my courtroom a few weeks ago. And I can say anecdotally, and again, I don't have real data here, but anecdotally I can say, as far as race and ethnicity goes, I was pleasantly surprised that our panel appeared as representative as they have in the past, if not more so, which was unusual. And that may just be a coincidence, who knows, but I've now seen this twice. I will say that age-wise, the panels are skewing much younger. And a lot of the excuses that I entertained, both for that death penalty trial as well as the grand jury, were from folks who were 65 or over. There were a large number of folks requesting those excuses. I think another population that we're looking at potentially excluding or not seeing as many of are folks who have children in school. So folks who are parents of children in school who are having to deal with the additional responsibility of facilitating virtual education. I did have a couple folks show up for jury service who requested that they be excused because they were the parent responsible for making sure that the kids made it to school. So that there may be that other sort of group that may inadvertently be excluded or, well, yeah, I'll just use the word excluded as a result.
Speaking of which, I have a 5th grader who's in a trombone lesson downstairs, so I'm hoping that no one can hear that. But and so another issue that was raised by the judge's comments are, number one, whether a judge agrees that there may be a fair cross-section violation, but another one before that is even, do I get a hearing to get discovery on this issue so that it's not speculation, so that we can, open up the records for some transparency about who's responding to these, who's saying no, who's getting the exemptions.
Interestingly, no one in my court, or perhaps it's just a matter of scheduling here, but no one's made that motion in front of me, and that would be, I could see that being potentially effective and illuminating.
I would, yeah. And it's nice to hear that there would be a favorable audience. So Ms. Boston, in Georgia, again, I know that it's mostly grand juries, but thoughts about what trends you've seen, and also assuming that juries, petty juries will eventually, even when we start up, might trend younger, fewer caretakers, et cetera. Do you have a sense of whom that will benefit? General thoughts on jury.
I don't have a sense yet of, how that will benefit. We have had discussions in every circuit was required under the Chief Justice's order every circuit was required to convene a jury trial committee that's comprised of judges, stakeholders, DA, public defender, private lawyers, and others to give recommendations and create a plan. And the Chief Justice wanted kind of all of the community to come together to kind of look at, for your own circuit, the issues. And so one of the things within our committee that we've talked about is who is going to show up, and what will that be a fair cross section of the community, and knowing what the judge pointed out, which is that COVID-19 has hit communities of color in a more difficult way than other communities. Now, DeKalb County, and this has come into play in our county because DeKalb County residents, we are a 55-45 county. 55% of our county is African-American. So we have a very large African-American population, and we have a very diverse bench, all of whom are aware of what much of our jurisdiction is facing and what communities of color are facing. So we certainly want to make sure that we're not losing that fair cross-section of people. We have not called in, but what I can say is we're prepared to, when we picked this grand jury, we summoned over 400 people just to pick 48, and it was close. And so we do continue to see what we ended up with was what I would say a fair cross-section based on age and race and gender. We ended up getting what we needed to. But we've talked about access issues. We've talked about how this pandemic will change what the makeup of your potential jury pool could look like. And I think it's going to be incumbent upon the judiciary to ensure that when these panels are brought into the room, that they really take a good look and make sure that we have not lost a part of our population. And again, I think age is a really big factor. 65 and older, we know, are considered high at risk for COVID and complications. And I can tell you that all of my judges have said, if someone is over 65, just by age alone, and they say, I don't want to serve, they're not going to make them serve. And I think that's the right thing to do given the data, but it does mean that people and in Georgia, you don't get in Georgia at 70, you can automatically get exempted from jury service just by being 70. But 65 is not an automatic exemption. That's kind of a new reality that our judges are going to have to just say yes to. So I do think it's an issue for the judiciary really to pay attention to. I know our public defender will look at it. I know we will look at it. And I can say that as DA, if there's an issue, we're going to support our public defender on this because it is what's fair and right in our system. And we have to make sure that the jury pool is a cross section of the community in order to ensure fair trials within our criminal justice system.
Mr. Sabelli, thoughts about current makeup of grand juries or petty juries, or predictions going forward about, I don't know, whom this may benefit? Who are young jurors going to, what are they going to do?
You throw me off when you call me Mr. Sabelli. That makes me scramble. So I can't speak about Louisville, I hope I said it right, or DeKalb County. You folks know that better than I do. But I'll say this, we had a fair cross-section problem across the country before COVID and before what we're calling social unrest, the George Floyd era, right? I would submit that across the country, we already had a fair cross-section problem, better in some places, worse in others, depending on what sort of system was being used for bringing people in. And if you want to make a silk purse out of a sow's ear, and sort of not waste this crisis, it's a really good opportunity to look at how juries are being selected. And so you've got two pieces of it. One is the fair cross-section piece, who's being brought in, and then what you do in the courtroom, whether it's judge-led voir dire or attorney-led voir dire, to try to deal with the problems. And the problems have to do both with the pandemic and as both Ms. Boston and Judge O'Connell have pointed out, also with the social unrest around the unjustifiable killing of lots of unarmed African-American men, and the social tumult, the social reaction to that, which has been there, but is really much sharper this year. And so the question is, how do you deal with that? There are some studies that, the National Jury Project did a study out on the West Coast about who's coming and who's not coming. But I would like to draw a really sharp distinction between who ends up coming. That's one question. And the other question is, how well are they able to serve? That's an entirely different question, which needs to be studied as well. Because just because you show up doesn't mean you're in the right frame of mind and you're not going to panic the second day of trial, or when the client, the mask goes a little bit lower on the client, or the client testifies with a mask or without a mask. There are all sorts of issues about the performance of a juror in addition to the selection of a juror. And these are starting to be studied, but we came at this from the background of already nationwide having real problems with the fair cross-section. Sometimes the data hasn't even been collected on this. So there ought to be some work making sure that we're collecting the data, and we understand who's showing up and who's not showing up. And again, there's a really good National Jury Project study on it. I think Lois Heaney was the principal author on that. Certainly, we can circulate that. But there are profound issues in terms of why certain people would show up or not, and how they would perform as jurors or not. And as Ms. Boston has pointed out, and I think Judge O'Connell as well, the rate of impact in terms of hospitalization and deaths is much higher for people of color. Also, the rate of infection for children of color is much higher. And for anybody who's a parent, that of course has a major effect on your willingness to serve and where your head is at when you're serving. So one of the things that makes me most uncomfortable with what we're doing with trials right now is we're blazing ahead with certain trials on the assumption that if somebody's showing up, they can be a good juror, or that things are more or less working, when we really haven't studied it. And so that puts defense attorneys in a position where they have to litigate hard, and super happy to hear about that example that Judge O'Connell gave, because that's exactly what we have to be doing. We have to be bringing this, we have an ethical duty to bring these concerns first and foremost to the minds of the judges, because if going forward without really knowing who's showing up and where their head is at is very difficult to do.
So we only have a half an hour left. We're 2/3 of the way through this, and we have a number of topics we haven't covered. Public access, attorney-client confidentiality, et cetera, victims, and other charging decisions, other things from the prosecutor perspective. But because not Mr. Sabelli, Martine, because of what you just raised, and some questions from the chat, perhaps we can talk for a minute about what's going on with in-person proceedings. So we've heard some concerns about virtual proceedings and right of confrontation, but in person even, there will be masks, there will be physical distance. So thoughts about, assuming that we're not gonna just shut things down for another 2 years, thoughts about best practices, what you've seen or heard or thought about yourself, in terms of how to ensure both safety, but also constitutional rights in the in-person courtroom in the near future. Judge O'Connell, thoughts about that? Yeah.
Yes, a lot. And they tend to change. Since my civil trial a couple of weeks ago, I am still of exactly two minds about whether it was a good idea or not. Just for a quick background, it was a motor vehicle accident where liability was stipulated, so only damages were at issue. The proof, the whole trial itself took maximum 2 days. And the first day was just jury selection because we brought our panel in groups of 15 and did voir dire 3 separate times to keep everybody appropriately distanced. It took a lot of choreography that even with me, waking up in the middle of the night for weeks ahead of time, trying to, concerned about the safety of everybody who entered my courtroom, there were things that we hadn't anticipated. I will say jury selection was a challenge, not only because it took a long time, and my philosophy going in was we'll take as much time as we need to get this right. So I wasn't rushing anyone, but at the same time, the Kentucky Supreme Court has put the safety and health of anybody who enters my courtroom on my shoulders. And so I also don't want people to be exposed to each other for prolonged periods of time. Jury selection was difficult, of course, because everyone was wearing masks. As a former trial attorney myself, I can't imagine how frustrating it was for the lawyers in the case to try to select a jury without being able to see their facial expressions, with being confined to sitting at counsel table and having to wear a mask themselves while they were questioning witnesses. You have, of course, the problem of, how close do you sit to co-counsel, to your client? We have plexiglass barriers and people wearing masks, but is that enough? Is that too much of a risk? Bench conferences were very difficult, very difficult. We all wore masks. I had plexiglass up at the bench and I just couldn't hear. And that was an issue with just sort of volume in general in the courtroom, is that some people were more soft-spoken than others. I had to constantly remind people to speak more loudly than they were comfortable with. It just, like I said, I'm of exactly two minds about that experience. Did we manage to do it? Yes. Was it a good idea? Was it effective? We got a verdict. It depends on how you measure, effectiveness. We got a verdict, but I'm not in any rush to do it again soon. I would do some things differently. And it's not perfect. It is certainly flawed. As you can tell just from my my body language and as I'm thinking about it, I really have been thinking about it ever since the trial, and I'm still of exactly two minds about it and whether or not it was a good idea.
These are challenging issues, as you said. Ms. Boston, thoughts about what would work best in person, what we should be prioritizing? Yeah.
So in our jurisdiction, and you know, we have not actually physically done the work in the way that Judge O'Connell has experienced it yet, because we have not begun in court appearances and not trials, but we're having these very discussions. And, you know, masking and, you know, how can you really pick jurors and examine jurors when, you know, we now have only eyes up, right? And we lose expression. How can we determine the credibility of witnesses on the stand when you can't see their full facial reactions or tell their body language? Not to mention that, you know, our courtrooms have been retrofitted. We have not used them yet. They're retrofitted, but they look like, in my jurisdiction, they look like ice hockey rinks, where there's this indoor kind of like warrior space. And so we, at this point, don't even know, once we get people in the room, like, what are people's vantage points going to be as far as visibility of seeing all the things that you would normally see when it's unobstructed. So these are all really, really important issues. I will say, I was on a call last night with several judges from various metro Atlanta jurisdictions talking about what each of their courts have done. And Judge Rob Leonard, who's taking over as the chief judge in Cobb County, which is a part of the city of Atlanta, in January, they had just completed a 2-day mock trial. They decided to put on, using, you know, courthouse employees and things, a mock trial of a trial, from the logistics of everybody coming into the jury management room all the way through presenting evidence and deliberate, just to walk through the process physically. It took them 2 days, and they said that they've learned a great deal of what's going to work, what's not going to work. And I can tell you that, speaking with my chief judge this morning, we were having the conversation about, hey, we hadn't thought about doing a mock trial, but I think we should, because we don't want to find out these issues that, like Judge O'Connell is talking about, that the judge can't hear a bench conference through the plexiglass. And I didn't even think about it, but as Judge O'Connell was talking, I was thinking, I don't think you can hear anything through what I call the ice hockey rink that now exists in our courtroom. And does that mean you're going to have to take, you know, jurors in and out of the room every time you want to have a bench conference, because it's no longer feasible to do it in a way that everybody can hear, including the court reporter trying to take down those whispered tones? And see, these are all things that I think logistically make it very difficult for us to do jury trials. And if I'm being quite candid, I'm not certain when we're going to have jury trials substantially in Georgia. I think it's going to be very difficult, especially in metro areas, to accomplish all of these things. I think we're going to have to find ways to move cases along. Having said that, my judges have made it very clear that the only cases, the priority cases for trials, the trials that we do have, are going to be our murder cases and our child molestation cases. And to Judge O'Connell's point about the civil case she just had, most of the judges in Georgia have said, if you are a civil lawyer, you might as well sit back till 2022, because they're not scheduling civil jury trials in person, because all in-person spots are being given to criminal cases with, in particular, priority to any person that is in custody. And so that's what we're expecting. We expect to only try murder cases for the most part when we start trying cases again.
And if I may just add really quickly, that's how it is in our jurisdiction as well. We are giving priority to in-custody criminal cases. The only reason that I ended up having that civil trial was because that death penalty trial was postponed. And this civil trial was the last one standing, and both lawyers said they were ready to go and wanted to try it. Even up until sort of the last minute, I kept saying, are you sure you really want to do this? And they did. And so I went for, we did it. But again, I'm not convinced that it was the best thing to do, but.
I mean, it's also the case, of course, that nothing was risk-free before the pandemic, that a juror could get the flu and die. I mean, this obviously is an entirely different situation, but that there will be risks to in-person proceedings in this messy business of criminal justice. And how do we balance these things was always an issue, even before this. Another thing that a couple of folks anonymously on the Q&A have pointed out, and I, could we use clear face masks? And I just wanted to mention that last time we had a conversation recorded like this, Judge Trina Thompson here in Alameda County was pointing out that she had actually just bought off Amazon with her own money some clear face masks for the folks in her courtroom, presumably mostly for the deputies and not all of the jurors in the veneer. But that sort of is a segue into the question for Martine, which is there a way to have in-person proceedings in this era anytime soon that comports with the Sixth Amendment, either from the point of view of, from everything in the Sixth Amendment? Is it even possible going forward?
Let me start by picking up on a small point that leads to a larger point. You mentioned that even before COVID, people might get the flu and die. And that's true. But the science on it, apart from the science on contagion and death and everything else like that, there's science about something called COVID fear that comes out of the people who were studying HIV panic and 20, 30 years ago. And so my point really in talking about this is that there's science out there. There are people who are studying these things. And as the sole lawyer in a family of scientists who routinely gets beat up by scientists for how superficial we are about our understanding of the world when we make big decisions, I got to say, yeah, we are. We somehow lawyers have, and this includes judges, we've played an outsized role in the history of the world, much more than we've contributed to knowledge. And there's a whole world of science out there that we routinely ignore when we say, well, let's set up the courtroom this way. And it doesn't surprise me to hear from Ms. Boston that in talking about this, it comes up, hey, well, why don't we have a mock jury? Well, people are doing these kind of studies all the time, whether they're mock jury studies or social science studies or airflow studies or contagion studies. There's a lot of science out there. And we as lawyers and judges have routinely ignored it. NACDL published a report in early June, which I saw Bonnie post in the chat. And one of the things we tried to do there was to raise our hands and say, pay attention to the science. If we're opening courtrooms or doing anything, it ought to be with science and certification of scientists. And that hasn't happened. So I don't want to fall in the trap of, as a lawyer, to start to say, here are the things we can do to make it safe. What I can do as a lawyer who has studied this as part of the NACDL project is say there's a lot of science that, for example, says plexiglass doesn't do a hell of a lot. Judges and lawyers are saying, hey, put up some plexiglass because they feel better about it. But the reality, it all depends on the airflow. So that's just a small point. And it illustrates the larger point that there ought to be public health certification and science behind whatever we do. The 6-foot deal doesn't really matter if you're in airflow. You're in the enclosed space and there's not a lot of airflow. 6 feet doesn't mean a lot, right? It depends on the masks that are being used, how many people are there, what the airflow is like. So there's a lot of things that we as lawyers think make sense, and we sort of say this makes sense and this makes it safe, and the science doesn't necessarily back it. So to come in for a landing on that, we ought to have a lot more attention paid to the science. Courts and lawyers ought to pay attention to the science, including scientific issues like HIV panic and that sort of thing, which is not just hard science. It's a different kind of social science. We got to have much deeper understanding of those things before we can sort of wade into the morass, into the marsh of what is safe and what is not safe. As a lawyer, where I can speak a little bit more comfortably, I really think it's, the notion of giving up the right to confrontation in person is highly problematic, and I don't see how we do that. I am very much against Zoom jury selection. I've seen some attempts at that in civil mock jury contexts, and it seems very difficult to understand whether or not the jurors are really paying attention. Even if you see their face on there, you don't really know what they're focused on, how seriously they're taking the process. So just to end here, I think we need to pay a lot more attention to the real science out there. And I think that very few of us know it. And finally, science has been politicized, and that's a serious problem in this day and age. People don't necessarily even trust science anymore, and that's a problem.
Martine, do you think that just in person, though, even with respect to confrontation, just the physical distance between the jury and the witness and the wearing of masks, and there's been talk about how clear masks likely will not meet public health certification until they've been modified. I'm assuming that's why Judge O'Connell was going like this when I was talking about clear masks. I mean, how do we get constitutional confrontation in person with the modified procedures we likely will have?
If you might conceivably have a courtroom that has been tested scientifically that allows for people to have the proper sight lines, enough distance, enough ventilation, guarantee some way for, let's say, if the accused wants to testify without a mask, because there is a real problem in testifying with a mask for all sorts of reasons, not only in a bank robbery case where a mask was used, but in all sorts of cases, right? And so there may be situations that can be scientifically certified where you can have enough distance, have some sort of airflow above everybody's head so stuff is immediately filtered. It's conceivable. It's conceivable that could happen. I have not seen it yet. And what really worries me is that things are happening with people just saying, oh yeah, let's put up some plexiglass, or let's live by this 6 foot. As long as jurors are 6 foot apart, it's fine. And we know that's not true. We know that 6 foot is an arbitrary figure. It's based on some science, but it depends on the airflow and how long you're in a room with somebody. So it's arbitrary in that sense. It works for brief public interactions. It doesn't necessarily work for a sustained courtroom context. That hasn't been studied, and the 6 foot thing has just been adopted as if it works in the courtroom as well. So what I can say to you is I don't think that anybody can certify any of this until there's been some real serious work done on it. The hard science of airflow and that sort of thing, the social science of how it's affecting the minds of potential jurors. And again, this has mostly been studied in the context of what was called HIV panic, but is now being studied in the context of COVID. And then apart from that, there may need to be specific things that we as lawyers and judges can figure out case to case. But we can't ignore the science that we don't understand yet.
And I realize I want to be mindful of time because I want everybody to have a chance to give some final thoughts and advice going forward to the audience. But some things that I know folks really want to hear, if you could be brief. First, for Martine, just quick thoughts about what's most important for lawyers to do to ensure as best they can the attorney-client relationship, just thoughts about jail visits, confidentiality, just in the courtroom. What should they be most prioritizing and focusing on given what their limited resources?
I think it's very difficult to construct an attorney-client relationship of trust now, but if we can argue for and get virtual meetings with our clients, we can do that and just triple, quadruple the amount of time we spend with them to construct that relationship, to try to overcome the lack of physical proximity. We can try to overcome that with much more time virtually. The real problem is investigation. I can't ask my investigator to go in the field. And even if I did, I can't be ensured that she will be able to get doors open. And so the real problem that I see in going forward now is the capacity to investigate on the defense side. And of course, that plays into charging, right? I mean, police investigators are having a tough time too, right? So it's not just on the defense side that the notion is we can't do lots of investigation, either side, to get it done. That most often is a disadvantage to the defense because we often come in after inculpatory investigation has been done, and it's our job to either address that, refute that, or do our own investigation. And so we're sort of behind the eight ball on that.
And then this is a great segue to another question we've gotten from the chat for Ms. Boston, which is how has this affected plea negotiations and charging decisions? How should it? What do you do about nonviolent offenses where there may be better alternatives to getting an indictment to begin with?
Yes.
So brief thoughts.
Yeah, so we were always utilizing diversion and accountability courts, and we are continuing to do that. Nonviolent offense, and I saw the question in the chat. I feel bad for our grand jury right now. There's no fluff to what they're hearing. We have filled the docket full of the most serious kinds of cases because we've put everything else on hold. And nonviolent offenses that can go to accountability court or be diverted for alternative programming, we've been doing that through the pandemic. Cases that were directly accusable and could be worked out to diversion or probation, non-confinement, we've been doing that. And our public defender continued to provide us with a list of cases that they felt, hey, look at these. We think these are all cases that can be worked out. So we have been tackling all of those issues, understanding that the spots for jury trials are going to be limited and should be limited to the most serious kind of offense, the kind of offense where people are facing life in prison, and the kind of cases that don't plead out, because murders don't plead, they go to trial. Everything else, we've got to engage in plea negotiations and find a way to do that. And I'm not sure we've done as much as you're seeing a little bit of a log jam, because there really is no incentive, especially if you're on the outside, you're like, time out, I'll just wait. You might not get to me for 2 years. Now, that's not the same with everyone, because some people's lives are on hold with criminal charges hanging over their heads. But what we have found is that we're getting the phone calls from people that are like, we think we can move this along and resolve it. And we're doing our best to keep up with that work, because that's all work that we can do, even if we're not having in-person hearings. Everything else is moving. And I'll put in a plug that our one of our diversion programs that is an intensive program for people that normally would not be diverted out of the system, we were in the middle of that program when COVID hit, and we migrated that program, reinvented it so that we could complete it via Zoom. With counseling, with the treatment, with all the programming that was all supposed to be in person. And we were able to graduate six of our graduates online just a few weeks ago. And for us, we felt like this is great because it was a program that could have easily died on the vine because we couldn't be together. But we found a way to modify so that we can continue to do the types of programming we want to do. We have to adapt because it's going to be a long time before I can run an in-person diversion program. So now it's online.
Before we give final thoughts, if each of you could just do one sentence on the public access, whether you have audio and video and whatnot, would be great to know for those on the chat. Judge?
So I think I'm one of the only circuit judges in Jefferson County, if not the only, that's using Zoom. I do make the hearing available by phone or by Zoom. I will tell you that I've been surprised at the number of lawyers who do not take advantage of video. I think it's a real missed opportunity for advocacy. And there have been times where a defendant is in jail on video and I can see him or her and they can see me. And then everybody else is on phone, including all of the lawyers involved, including that defendant's lawyer. And it just seems like a problematic. Let's just put it that way.
Got it. Ms. Boston?
One of the issues that we've faced with public access, most of our proceedings via Zoom are then uploaded to whether it's YouTube or Facebook or some other method of blasting it out to the public. We encountered issues around victims' privacy, although the court is open. Normally you have to come down to the court to hear the testimony instead of these proceedings being on Facebook, and it became like popcorn and wine fodder for people. And we had to figure out ways to shut down chat rooms where people were just watching for fun and commenting on the looks and the appearance of public defenders and ADAs, even the judges. We had someone calling someone like hot chocolate judge. I mean, it's just, and it degrades the proceedings when victims or family members of defendants or witnesses are sitting and watching these comments come up. So those are all issues that we have to make it public, but then we were inundated with kind of the informality and the types of messages that wouldn't happen in a traditional courtroom. A judge isn't going to allow people to sit on the sidelines and chat. But when it's on social media, the judge can't control that. And so we've had to work through a lot of those challenges that being in the public, but on social media has brought into courtroom proceedings.
An interesting point about, what becomes the record on appeal then too. It's like the chat transcript and what's going on with it. Martine, thoughts about public access in the Bay Area? Or?
Well, I agree with the notion that there's a right to public access, obviously. That's not the same thing, as Ms. Boston has pointed out, as the right to contemporaneous public comment in the record. That's problematic, even if it were serious comment, like, I think that witness is telling the truth, or I think that witness is lying. That public shouldn't be intervening in that way. So I completely agree with that. And I think technologically, though, I'm the last person you should ask about this, that could be controlled, right? That could be controlled. There can be ways to do that. And here in the Northern District of California, there is public access, but people are not allowed to, turn on their camera or turn on their phone or chat. So that's great. I will say this. This is one of the areas where perhaps there's a silver lining, right? The silver lining is maybe more people are going to become familiar with the criminal legal system. I've been in these, used the word in the beginning today, trenches. I've been in these trenches a long time. I think a lot of people would be very surprised if they knew how their criminal legal system worked or didn't work. And take a good look at it, might be actually a real silver lining. The other one is, for misdemeanor clients in state court, sometimes they got to lose a whole day to go to court and sit there and have their case called for 3.5 seconds. And they've had to pay for, child care. They've lost their job. They paid a friend $20 to drive them or whatever. Having those kind of hearings not be in person and have those be, non-substantive hearings done in that way might be really important, because there's a kind of disruption that happens to you when you're charged that can have you lose your house, have you lose your job. And so maybe that's a silver lining. That is not to say that I don't want in-person proceedings generally, but there is certain categories where there might be a little bit of a silver lining.
And likewise for alleged victims and witnesses for non-substantive issues. I realize we only have a minute left. I fear that's not even enough to give your general thoughts, but if the hosts are willing to allow us to hear at least one sentence, any final thoughts?
Go right ahead.
Okay, great. Judge, final thoughts, advice, predictions?
One of the aspects that hasn't been discussed really during this discussion is how Zoom hearings and remote hearings have affected judicial decision-making. And I think it's important to also note, and there needs to be more study about how conducting hearings remotely potentially affect the decisions that judges make. Having a judge is already removed by, spatially from the folks in their courtroom, but when you can't see someone, or if you only see them by screen, does that impact a judge's decision making? It's navigating the technology and the screen and all of those things have become an aspect of this system. And I just don't know. I'm trying to check myself, but I don't know how or if that is having an impact on my decisions to probate versus send folks to jail or prison. I think that's another thing that needs to be studied.
Ms. Boston?
Final thoughts is that this is a marathon and not a sprint. I think just as we've dealt with the public health crisis, we're on week 36, I think 37 of being home. If you had asked me back in March, when I sent my staff home on that Friday, I told them they'd be going, we'd be remote for 2 weeks. My executive team, we had said we were planning for 4. And here we are 36 weeks later. And I don't think restarting our system is going to be like turning on a light switch. It is going to be like turning on a dimmer. Given what we know about the science and public health and where we are and what it's going to take to get the entire country vaccinated, I think we have to expect that this is going to be a slow return, and we're going to have to continue to find innovative ways to operate and preserve the rights of victims and defendants, given the constraints that we are going to continue to have to work under.
Martine, final thoughts?
Yeah, I don't even really have anything useful to say except to point out 2 areas that we haven't talked about. One is the ethical concerns that lawyers have. I live with my 83-year-old mother. Am I really going to be able to focus if I were forced to go to trial, or am I going to be worried about my mom the whole time? Right? And so there's some real ethical issues that go on here. I need to talk to my client, but I'm not going to get close to him or to her because he or she's been in a facility with a lot of COVID. I'm in my head, whether it's conscious or not, I may be prioritizing my personal health over my communication with my client, or vice versa. But it's not a good situation. The other thing is, God bless you. There you go. Oh, what a mask on.
COVID panic.
The other thing is, let's be real. We don't really have many trials left in the United States anyway. And one of the concerns I have, because of the disappearing trial, because of the trial penalty, which is really a focus that NACDL has, is that this situation is going to continue the erosion or disappearance or extinction of trials, which our founding framers believed was as important as the right to vote, because it was a way to protect liberty, to bring out, to make sure that the government in all of its branches is working correctly. And I'm concerned that a consequence here is we're going to have even fewer trials, and trials are going to just disappear.
Hopefully there will be a way to turn this into some sort of opportunity, maybe make the system less bloated, focus on cases that should be brought, and give them some sort of procedure that comports with the Sixth Amendment. But it won't be tomorrow.
Never waste a good crisis. Never waste a good crisis.
Never waste a good crisis. Yes. So I'm going to turn it back over to our hosts, our NACDL hosts. But thank you to everybody for coming. And Monica?
Thank you so much. So there's nothing like hearing the on the ground experiences. As much as I've read about all of these things that we're talking about, it's just really a tremendous learning experience for myself, and I'm sure all the viewers, from hearing from you. So I want to thank you all for joining us today. On behalf of NACDL, APA, NCSC, and RTI International, I just want to thank our panelists, our moderator, and viewers for joining us for this discussion.